In State versus Sandoval, the state Supreme Court, just like in the Kenneth Wood case, ruled that there is no duty to retreat in order to exercise self-defense. This is further solidified by a recent case here in Multnomah County. You guys may have seen this in the news a few months ago. There was a FedEx driver who was driving, he was black, driving on his truck route. Someone started screaming at him from the side of the street, some racist comments of some sort. He decides to get out of his truck. And I don't know all the details. I'm not necessarily ragging on anyone in this particular case. I don't know exactly what happened. So he gets out of his truck, goes and confronts the person. The person is throwing a water bottle or something. He punches the guy, knocks him out, kills him. That was ruled to be self-defense by the same Multnomah County District Attorney's Office. And in fact, in their press release, they say there's no duty to retreat. So the judge also said, he said this was an unlawful escalation. If what I did is an unlawful escalation, then by default, he's saying that the actions of the mob were a lawful escalation. And that's the scary part. During pretrial arguments, he referred to numerous hypotheticals involving a counter-protester. Again, I wasn't there to counter-protest. He said during the sentencing, when I gave my short statement that I believed that I was about to be, beaten and robbed, and smashed on the pavement, he said, "You were not about to be pummeled. You cannot react in the way that you did." I want to know where his interdimensional time machine is. How can he say that without being able to go back in time and observe a different reality where I didn't pull the gun? I don't have that luxury. Apparently the judge does. What's interesting is the judge is sort of inserting his own mindset as if it were mine. My appeals attorney is particularly citing this for things that we can bring up for other legal maneuvers. So they're saying that there are 10 victims involved in this for each person who was in the immediate peripheral. Only 2 of them ever came forward. Carenza and Chaddock. Carenza, the guy who started the thing. Chaddock, the other guy circling around me, now coming up on my 4 or 5 o'clock position. Was the only 2 people who ever came forward. None of the other people were even identified. We didn't even know their names. They had masks over their faces, and/or they didn't want to come forward. They could very well have had warrants out for them. Maybe they knew they were the ones committing crimes on that day, and they didn't want to come forward because of that.
11 if you count Sawyer.
So I have a constitutional right to face my accusers. I was denied that right. So the judge had issued his verdict, guilty on all accounts. And you could hear the air getting sucked out of that room. In fact, there's 2 people in this room, maybe 3 people, I think, who were at that when the verdict was announced. Everyone was in shock about this. Because clearly this is a prime example of self-defense against mob violence here. So by finding me guilty, the judge has ruled that a person does not have the right to freedom of the press. You do not have the right to be in a public area, filming a public event, exercising your freedom of the press. Instead, a mob of thugs with masks over their faces and sticks in hand have the legal right and lawful authority to use physical force and intimidation tactics to prevent you from doing that. I know there's a lot of journalists in the room. That should scare the bejesus out of you right there. Whether you're a mainstream journalist, whether you're an independent journalist, guerrilla journalist, it's a very scary notion right there. It's perfectly legal for them to do that to you. It's a crime if you try to stop them from harming you. And this extends to other things too. Freedom of the press is a constitutional right. Standing on the street, doing nothing isn't necessarily a constitutional right. So I have even more clout to be there doing what I was doing than someone standing in the street. There's been a lot of talk of attacks on people lately, especially with the political violence that's gone on downtown. That was essentially legalized in my case. The judge has ruled that mob violence is legal. So in an effort to try to lambaste me, they've inadvertently given carte blanche to the KKK to attack black folks on the street. Because they have masks over their faces. They can have weapons in hand. They're free to do that. If the black person they're targeting tries to defend themselves, that's the person who's guilty of crimes. That's the unintended consequence from everybody who was piling on with me in this case. And even scarier, this extends further. So according to the judge, DAs, and police, if you did this to them, they would not consider it to be unlawful physical force. If you see a police officer walking down the street, according to the judges and DAs, you have the right to do to them what the mob did to me. This extends to activists, probation officers, journalists, the governor. She doesn't have special privileges over the rest of us. Now, this is not a case. I was convicted of 21 counts, 10 felonies of unlawful use of a weapon, 10 misdemeanors of menacing, 1 misdemeanor of disorderly conduct. Now, I understand most of these cases. I'm sure you could vouch for it. Most of these cases involve someone who is robbing the liquor store, someone who's trying to carjack someone, a drug deal gone bad. This is completely different than a lot of those other cases. You know, what was going through my head was not, yeah, I'm going to go and commit a crime. It was, these guys mean business. They're about to pummel and rob me. There's no police around. Many of them have masks over their faces. They'll never be identified. There's no consequences for them if they beat me and rob me. There's no consequences for them if they beat me and rob me. If I do not act right now to defend myself, I'm toast. I'm flattened into the pavement. So I was sentenced to 3 years of probation, 40 days in jail, and 240 hours of community service. Now, the jail days were to be served on weekends, which isn't even real jail. Yeah, it's still cumbersome. It's a big inconvenience for me. I missed out on a lot of work. Weekend jail, you show up to the courthouse, not even the jail, but the Multnomah County Courthouse. And they lead you up to the room on top. If you've ever been in there in the jail scrubs, then it's the room where you're waiting for your court appearances. And you basically sit in there all day and watch movies with 20 or 30 other guys. They bring you 2 crappy bologna lunches. And then you go home for the night. You sleep in your own bed, you get to check your email, you get to eat a real meal. Then on Sunday you come back and do it again. Now, I had 12 days credit served already, plus 4 days of good behavior, so that was a balance of 24 days that I did on that throughout the summer of 2017. Originally, the original sentencing, he changed it a little bit from what the pretrial release officer had done. The judge initially ruled that I could not film any person as my special conditions, in addition to the normal things that when someone's on probation. So 5 weeks later, we were able to get some of that lifted. I still have a lot of First Amendment restrictions. I am banned from filming protests. I am banned from filming anything at PSU. I can't film my own speech right now. If I film my own speech, I go to prison. You know, there's a lot of this rhetoric about Trump's attacks on the media. Has Trump ever threatened to throw someone into prison for engaging in their First Amendment rights? I'm experiencing that right now. It's not Trump threatening that. It's the judges in Multnomah County that are threatening that. But I'm not banned from going to political events, which I think is interesting, because if the judge is ordering that as a way to protect the public, because he doesn't want the incident to happen again, doesn't want a redo of everything, then why aren't I banned from going to political events in the first place? Because if it was my intention to do that, having a camera or not wouldn't matter. In fact, if it was my intention to do that, why would I bother following that order in the first place? Yeah. So while I was in weekend jail, I was actually denied some deferrals to work. I'd been offered some weekend work. I do a lot of freelance work, video production stuff. I'd been offered some work throughout that summer, and I had heard some other guys doing weekend jail who were able to get permission to defer some of those days. Where they can go to work, and then the days that they miss just get added on at the end of their thing here. I was denied that. You have these other guys who are approved to do that. There were other guys in there who weren't even asking for permission to take a weekend off. They just weren't showing up. One guy wanted to go rafting on the river with his buddies because the weather was nice out. Another guy, he was scared. He was a younger guy. He didn't know what was going to happen, so he just didn't show up because he was scared. He actually tried to turn himself in at the normal jail later that week. They didn't take him. There's a warrant out for him. They didn't want him. So he showed up for his normal weekend job. No consequences, no extra time, no fines, no new charges for that. But I'm denied that for legitimate work reasons. So if it can happen to me, it can happen to anyone. And that's where I really get concerned for the general public at large. You know, about the attacks on LGBT folks. I know you were bringing some of that up, and some other folks were. You know, they don't have the right to try to stop someone from beating them. If they do, they're the ones who go to prison. I don't care if you're black. I don't care if you're Asian, Islander, Native, transgender, non-binary, gay, straight. Everybody should have the right to defend themselves against that sort of thing. And I don't care who the aggressors are, whether it's Antifa, whether it's the KKK, whether it's just some street gang wanting to cause trouble, whether it's some guys who need money for their fix, they're trying to rob you. This affects everybody to the core. So we are now in the appeals process. My attorney on the appeal is Robert Barnes. He's an attorney to the stars of sorts out of LA. He's representing some of the Covington kids, actually. He's not the one I had on the trial. That's a talk for a different day. So in the appeals process, you're not necessarily going back, and I wish Sergeant Halliburton were here to show the video. You're not necessarily going back and re-arguing the case. You're not going back and looking back over evidence or arguing innocence or guilt. You're addressing errors that were made on the trial level by the judge. Now, most of these cases that I've seen, as I've investigated these, involve one assignment of error, as they call it. My case involves 6. We're limited to 10,000 words. It would have been probably a dozen if it wasn't for the word limit. So the things we've raised on the appeal, several of them center around my state of mind. Again, the judge denied all those motions that relate to my mindset and what I was thinking at the time. And because of the case law precedent set in Oliphant and Wood, self-defense is purely in the state of mind of the person who's raising self-defense. So change of venue is our first one for assignment of error. What happened to my arm and the fact that that was ruled inadmissible, which certainly plays into my mindset. That's one of our things. The definitions of unlawful use of a weapon that the state refused to clarify, because in our point of view, that left me with an impossible defense because I didn't know what I was defending myself against. The statements to the detectives, the ambush witness, we argued as an error because there actually are not only laws involving that regarding proper procedures, but also case law. State v. Flygare is a state law involving that, where they can't present ambush witnesses. And the First Amendment restrictions. So those are our 6 assignments of error. Now the appeals court relies on typed out transcription of everything. We're not going back and listening to the audio. I have the audio from the whole thing. Someone has to type it all out. They have to listen to the audio and type it all out. So that was ordered right away in May, I think, maybe June of 17. The trial was February of 2017. The sentencing was May 3rd of 2017. So we filed our appeal in timely manner later in May. The transcriptions were ordered, and it took them 4 months to get us the transcripts. My appeals attorneys say they've never seen anything like that take so long. We filed everything in a timely manner. They're allowed to take all that long. They're allowed to continually ask for extensions. So we finally get the transcription, and we put together our written brief, and we submit that in a timely manner, which was then, so we got the transcriptions in October of 17, and we got our written brief in mid-December, I think, which then puts the state on the clock for 45 days to submit their response to our motion. So that puts them out to late January. And then I'm told in late January that the state, person handling the state here, Susan G. Howe, has now filed a 131-day extension of time for her to put together her response. She writes in her